G'day, ladies and gentlemen. We're joined today by Angus Murray. He's partner at Irish Bentley and adjunct lecturer in law at USQ. And we're going to be having a quick chat about the unfortunate New York lawyer that used ChatGPT to draft some submissions and very publicly came unstuck. So that is Matter and Avianca. Angus, can you summarise the matter, the facts of the matter for us?
Yeah, it's, as you said, David, very unfortunate tale to be told, which is unfortunate only in the sense that the tale needs to be told, of two lawyers, Peter LaDuca and Stephen Schwartz, and a law firm, Levidow, that had relied upon submissions wholly created by the platform ChatGPT in relation to a person's claim against an airline, that person, Roberta Matter, which is the proceeding within which US District Court Judge Castell made an opinion on sanctions and orders against the lawyers for their reliance on ChatGPT submissions. The issue that arose in this proceeding was ChatGPT had done exactly what it was asked to do, which was to create compelling submissions on questions of law, and had done so in a very effective way, such that it created the underlying decisions that it was relying upon. Only before the learned judge did that come out in its true force, that the court wasn't able to locate the existence of those decisions, and then it came to bear that the trial advocate and the attorneys in the case had used ChatGPT in lieu of other platforms because their traditional research wasn't able to locate a basis or submissions, so they thought they'd give ChatGPT a go. They lacked, I think, the knowledge about how ChatGPT works and probably placed an over-reliance on ChatGPT as a legal research tool. And that's ended up with them having to issue apologies and fines for their misleading the court. And I think a great way of summarising the case outside of that is what the learned judge says in opening, which is, quoting, "In researching and drafting court submissions, good lawyers appropriately obtain assistance from junior lawyers, law students, contract lawyers, legal encyclopedias and databases such as Westlaw and LexisNexis. Technological advances are commonplace, and there is nothing inherently improper about using reliable artificial intelligence as a tool for assistance. But existing rules impose a gatekeeping role on attorneys to ensure the accuracy of the filings. Those lawyers abandoned responsibilities when they submitted non-existent judicial opinions with fake quotes and citations created by the artificial intelligence tool ChatGPT, and continued to stand by the fake opinions after judicial orders called in their existence into question." And I think that lays a nice framework for a discussion about the rules and obligations we have in Queensland.
So the obvious takeaway, don't cite it if you haven't read it, and if you sign it, you own it. What are the deeper understandings you think that we should take away from these guys' misfortunes? I mean, it's always nicer to learn from somebody else's stuff-ups than ours.
I think there are a lot of lessons, unfortunately, that will continue to be learnt through the process of law practices' adoption of advanced technologies, particularly generative artificial intelligence. I think the basic proposition in this is quite simple. It goes back to the oath or affirmation of service and office that was made by all of us on our admission under sections or regulations, rather, 17 and 18 of the Supreme Court admission rules. And that imposes an obligation on legal practitioners by undertaking to the court that they will act in a certain way. And my summary of the 3 points that come out of that oath or affirmation of service and office is that we're required to act with knowledge, with ability, and with honesty. And I think this decision just really reinforces that where the knowledge isn't one's own and it's created by a generative artificial intelligence tool, there's an issue. Where that tool is effectively the outsourcing for legal services, there's a lacking in ability. And there's a lack of candour and honesty in the use of that, and particularly when it's progressed through the courts and lawyers stand by representations and submissions that weren't human created or at least human reviewed. In terms of the lessons to take from that, I think the short form of it is technological advancements, as the judge says in this decision, are occurring, and they are a good thing for the legal profession, but they must be contained within the parameters of human oversight and human responsibility. And that means more than just allowing generative artificial intelligence to do something and treating these tools as if they're law students, subject to compliance with the Australian Solicitor Conduct Rules, which I think imposes higher burdens on the use of generative artificial intelligence than simply delegating something down to a law clerk or to a junior solicitor.
Yeah, I'd put ChatGPT forward around about the level of an enthusiastic second year with a tendency to cut corners. So can we prompt engineer our way out of this? Is it just a matter of getting better at the questions we're asking, or is there more fundamental limitations in the generative AI technology which we need to just understand?
I think that's a near impossible question to answer at this stage. And to the extent there is an answer, the answer is these tools are getting better and better, and they will eventually get to the point where that enthusiastic second-year law student becomes a junior solicitor and potentially advances beyond that point. The difficulty I have with that is the importance of ensuring that the law practice that's using these kind of technologies is making appropriate disclosures to their clients about how they are operating and what their costing model is, where these services are effectively outsourced to technology. And I think that sits within Rule 4 of the Australian Solicitor Conduct Rules in terms of the competence that lawyers have. So although technology might be a shortcut and it might get very good and very appropriate to use these things, I think the obligation of competence and the obligations imposed by the undertaking under Rules 17 and 18 of the admission rules require still solicitors to understand how these tools are developing outcomes and how the prompts result in decisions being made within artificial intelligence, so that seeming shortcut is actually a much longer path when it's applied competently. There's also then obviously issues with confidentiality imposed by Rule 9 of the Solicitor Conduct Rules, and likely will be imposed under the amendments to the Privacy Act through the Privacy Act review that will require a much more stringent siloing of data sets that are used by generative artificial intelligence. And I'd particularly caution against using open source or open access libraries or generative artificial intelligence large language model programs, because the inputs to that have the potential to be a disclosure that breaches the confidence that ought to be maintained for clients. In terms of internal systems, there's likely also an issue under Rule 3 of the Solicitor Conduct Rules in terms of conflicts, where information that exists within these data sets may have a tendency or a circumstance where an actual or perceived conflict of interest could arise in relation to the training data that is available within these systems. And then finally is, I think the overarching point under Rule 13 is the requirement of supervision of lawyers in practice and an understanding of the work that they're doing. And again, going back to this decision in matter in Avianca, the highest importance is for lawyers to understand what they're doing, particularly and in any event, when something ends up before a court, that they have the ability to say honestly, with ability and knowledge to a court, that a decision exists and it stands for a certain thing, rather than a mere reliance on the work of another or the work of a computer program, as was the case.
Yes. There's nothing new in that. I mean, we've always adopted other people's work, and we always accept that when we're the one fronting the judge, it's our responsibility for it to be accurate. And if it's not, then God help you. So, look, thanks very much, Angus. Is there any resources that you think we should direct people to? Or?
Yeah, David, there's a number of resources on the Queensland Law Society's website. I'd particularly direct people towards the draft artificial intelligence use policy that the Law Society has. I think it's an excellent resource for law firms to use and tailor to their own design. And I think these policies and internal documents about how these technologies are used and in what circumstances clients are aware, and to the extent that clients are aware contractually when these services are used, is incredibly important. So I'd strongly suggest that everyone has a look at that artificial intelligence policy and the cloud storage policy that sits alongside that. Obviously, there's a natural connection.
Thank you very much. I think this will be the first step in a very long conversation that will probably see both of us out. And thank you for joining us today.
Thank you.